Well, welcome back to another Cordell and Cordell Town Hall. I'm Scott Trout, CEO and managing partner of Cordell and Cordell. We'll continue to bring you information for guys before, during, and after divorce and all things regarding family law. Today is no different. We're going to be joined by a panel of Cordell and Cordell attorneys from around the country. We'll be discussing a second part series of the 5 more mistakes guys make when facing divorce. This is the continuing series that we've done on our 10 stupidest mistakes guys make that we used to do in person around the country. We also have a book on this topic as well. And I know that many guys going through these seminars and hearing about this information, they relate. We've all made those mistakes and we certainly can recover from them. That's the point of today's conversation and our town hall. Keep in mind that obviously our panel isn't licensed in every state around the country, neither am I. I'm licensed in Missouri, Illinois, and Georgia. We cannot give you legal advice during this town hall, and we don't want you to understand that this is an attorney-client relationship either. What's important is to get you and to have your facts presented to your attorney in a setting in which it's more conducive to giving you advice. Obviously, if you need a consultation, we're available. You can call us at 866-DADS-LAW. Go to the web at cordellcordell.com. You can find out more information. You can do a consult via Zoom, in person, on the phone, whatever is most convenient for you during these uncertain times. We will have an opportunity for you to submit a question in the Q&A section where we'll address those questions and you'll get answers from our panel today. You can do that right now. Just go ahead and put your first name and your state. And if you're among a state in which our panel is licensed, we'll certainly try to get that to them to get you the most appropriate answer that we can, but doesn't replace that consult. We encourage you to do that. We want you to take notes. This is informational, educational. We want to spur a conversation between you and your attorney. And obviously, if you need one, we're certainly available around the country, including the United Kingdom. If you don't want to submit a question today, you can submit those to coronavirus.divorce@cordelllaw.com. We'll address those questions in our podcast that we have twice each week. I encourage you to check out our YouTube channel and across social. You'll find out more information, more resources, and things just like this, addressing topics for guys, not just in divorce, but again, before, during, and after, and all those things affecting guys in the middle of family law cases. So let's go ahead and get to it. Keep in mind, Q&A section. I know you have questions. Go ahead and submit them now. We'll gather them. We have some already. We want to address those for you sometime in the second half of our town hall today. So let's get right to it and introduce to you our panel of Cordell and Cordell attorneys. Coming in, Baltimore repeat guests. We have Kumudha Kumarachandran. Welcome.
Hi, Scott. Thanks again for having me. As Scott said, I'm from the Baltimore office and I'm licensed to practice in Maryland. I've been with the firm for 3 years and I've been practicing for 8. Fun fact about me, this is my 5th consecutive year being named a rising star by Super Lawyers Magazine.
Thanks, Kumudha. Glad to have you. And joining us from Marietta, Georgia, Adam Sutton. Welcome, Adam.
Hey, Scott. Glad to be here. I am a senior litigation attorney here with the firm. I've been with the firm practicing in Georgia for the last 5 years. I've been practicing law in general, almost exclusively family law for the last 10 years. My practice all around the metro Atlanta area. I'm also a member of the multiple different county bars and a former president of the state bar's dispute resolution section.
Thanks, Adam. Bringing you attorneys from around the country, trying to get you different perspectives. We're going to be joined by Lauren Gilbert in Dallas office. Welcome, Lauren.
Good morning. My name is Lauren Gilbert. I'm a litigation attorney in the Dallas office, and I have been fortunate to be with the firm for 2 years, and I've been exclusively practicing family law in the DFW area for the past 5 years.
Thanks, Lauren. Rounding out our panel for today, coming from Midvale, Utah, we have Jacob Arijanto. Welcome.
Hey, Scott, glad to be here. Jacob Arijanto in the Salt Lake City office. I'm a litigation attorney and I've been with the firm for about 2 years.
Thanks, Jacob. As I mentioned, we're getting some questions already coming in the Q&A section. I encourage you to do that now. We want to answer the questions that you have and get you some information and point you in the right direction. So go ahead and do that. We're going to gather the questions that we have that are rolling in. We'll address those just after the midway point, somewhere around there as we continue to go along, monitoring how many questions are coming in so that we can get through all of them during that second half period of our town hall today. If you don't want to ask a question live, again, you can submit those at coronavirus.divorce@cordelllaw.com. So before we get to the 5 mistakes, I'm going to give you a chance to get a pen and a paper and get ready to take some notes. But let's go to a real quick break, and we'll be right back and start our town hall.
Even in the toughest of times, there are usually opportunities for relief. Many husbands and dads listening now are struggling to stay current on alimony and child support orders. You should know that this crisis may allow you to modify your support obligations, but time is of the essence. If you're a guy needing help right now, not someday when things are back to normal, call us at Cordell Cordell. This is what we do.
Welcome back. All right, let's get started. You know, when we usually do these seminars in the evening in a live audience, and we have a lot of questions that come in, and we get guys that say, yep, made that mistake. But we'll talk about those mistakes and how we recover from them, and gonna go through some of our experiences with our panel. Kumudha, I want to start out with you. And in my seminars that I give on this topic and in the book we've written, obviously for me, this is the most appropriate place to start, and it's about moving out. Guys, I'll do a consult and they'll say, you know, should I, do I already moved out? What happens? Kind of, you know, what are the consequences? Is that a mistake? And oftentimes I always start out by saying it is a mistake to move out. And I'm very interested in your thoughts, but let's start out with, for guys that are watching right now and are listening, if they're thinking about relocating or getting out of the marital home, why should they stay in the marital residence?
So Scott, there's a lot of good reasons to stay. First of all, you don't have to leave. I think a lot of people assume that the man has to leave the house, but you have all right to be there until there's a court order or you guys have an agreement otherwise. I would certainly wait until that point to leave the house. The other, good thing about staying in the house is your maximum exposure to your kids. You're staying with your children, you're showing you're putting them first, and you're going to be as involved as possible. It also reduces the risk of, your wife withholding the children, and you have to comply to her terms in order to see them. So it is best to stay in the house, especially for you financially as well. You're not going to get stuck paying a mortgage and a rent or living with your family for an indefinite amount of time until you get a court order. But I will say there are some downsides to staying. So in my jurisdiction in Maryland, if it's a contested case and there's, hasn't been adultery, hasn't been any physical abuse, you have to have a 1-year separation period. And you have to have a 1-year separation period before the time of filing, which means you've had to have been separated for that time. The clock doesn't start until you move out. So that is the one cautionary tale I will say about moving out. But for the most part, I would not do it unless you're coming to a temporary agreement with your wife or there's a court order saying otherwise.
Yeah, we talk about why stay. And I think when I give this, topic into seminars where I talk to guys frequently, the biggest thing for me is a status quo may not be the status quo if you move out. When you mention it, when you talk about if you move out, you may have an agreement with your wife or your spouse that says, oh yeah, things are going well. We'll just see each other. We'll split the kids 50-50. Magically, things change when you move out. And now you turn into a every other weekend father and you can't control it. I've always said it's about being a passenger on that bus. And there's a reason you stay. And that is you get the same access that you had during, this period of uncertainty and whether or not you're going to move out than, otherwise moving out, right? I mean, you're going to see your kids every day and you have some control, right?
Yes, that is true. And it is the best solution. Like I said, people can, and I've had this happen to a lot of clients, is people can, your wife could keep your kids and dictate how you see them, if she has to be present or if you can only see them every other weekend. So it is beneficial for you and your relationship with your kids to stay in as long as possible.
Now, as you mentioned, the downside, I mean, the false allegations, the arguments, some things in which they say, oh, he threatened me, he's abusing the kids. We know that perhaps, at least in my experience, I've been doing this for 28 years. It is probably the most abused statute or law, and that is, in some respects, orders of protection, where if you stay, a downside could be a false allegation that's raised against you. And now it impacts your custody, right? If they claim and say, oh yeah, he was, abusive to me both physically and emotionally in front of the kids while you stay. Isn't that a downside?
That is certainly a downside in staying. And I mean, in Maryland, that happens a lot where people will file a protective order just to get the other party out of the house. And that is unfortunate, but that also, you can kind of minimize the damage. You can stay in a separate area of the house, focus on the kids and try to document as much as possible. Even though you're in the same house, try to communicate to your wife by text or in writing. This is the age of the internet. So if you have security cameras in your house, this, that, and the other, at least you'll have that evidence to show it did not happen.
And kind of to swing back, and you mentioned it a little bit about why stay, and that is, and I've referred to this as double household expenses. Inevitably, I can tell you when a guy moves out, again, they have an agreement, and here's the way I describe it. When you got married, imagine, you sat on the same side of the table, your spouse was next to you, you had friends, family on the other side. Now, because you're in the middle of a divorce, those roles have changed. Your spouse is now on the other side of the table, and you don't have necessarily those types of agreements that you think are the bond that keeps you together. And so when you move out, I can tell you from experience, lawyers on the other side are going to tell your spouse, don't pay the household expenses, don't pay the mortgage, don't pay the utilities, let them go into default, put it on him or her just to make sure that they pay it. So it is a conversation. The point of, I think, and I'm curious your input on this, is having a conversation with your attorney to make sure it's the best choice, because every choice and every action you take has a consequence. It's a domino effect. And obviously we may conclude that this is the best course of action is to move out. But the point of this mistake and showing what we see collectively is our experience of what it is. So, hey, if I choose, I may be facing double household expenses. I'm just curious as your input to round out this topic.
Yeah, I think that you definitely may be choosing to pay your own rent and your own mortgage. And also, if you go move in with a relative, you might be, and I've had this happen so many times, you might be stuck there for a year. So you really need to think about what the consequences will be when you leave. And that's definitely a discussion you should have with your lawyer. I always weigh out, because of this 1-year separation period here, I kind of always weigh out the consequences with my client and the ability to file for a divorce before they're separating.
Yeah, and I think that's a good transition point as we go to Lauren. But before we get there, Lauren, I want to talk obviously with you about waiting for your ex or your spouse to file or filing first. But quickly, guys are sitting here thinking, well, I moved out, I've just made all these mistakes. In fact, everything you said is coming true. It is not too late to have a conversation, perhaps about getting back in the house. So schedule that consult with your attorney if you have one. Have this conversation. How do I get back in the house? Is it appropriate? Does it give me an advantage? So all is not lost. That's what we started out with by saying there are things you can do to change course. So again, it's not the death knell. If you haven't made that choice, have a conversation with your attorney, prepare a strategy. So we were talking about expenses, Lauren. I want to talk about waiting for your spouse to file. I'm just going to let her do it or him do it. I want the blame to be on them. But I know you've referred to this as kind of the Wild West as it comes to expenses. So maybe you can talk a little bit about why guys should be thinking about filing.
All right. Well, absolutely. It is the Wild West. You guys were talking about you've got this period of uncertainty. And so until there's a court order saying who has to do what, it's up to you and your spouse on who's going to have the kids when, who's going to pay what expenses, who's going to use what property. There's no rules really in place. And so if you're just waiting on your spouse to file, you've got this period of uncertainty. Are my bank accounts going to be withdrawn down to zero? Who has to put money in the joint account to pay joint expenses? When do I get to see my kids? And so it's chaos. It's the Wild West. And so if you're dealing with this uncertainty, or you want to prevent that uncertainty to go from coming into place, you want to go ahead and file and start getting your foot in the door. A lot of counties, not every county, but a lot of counties have what's called county standing orders that are essentially Band-Aid orders that try to minimize some of that chaos. And so they'll say, hey, you can't drain the bank accounts. You can't kick the other person out of the house. You can't move out of state with the child. You can't sell his golf clubs for $1. And so they're designed somewhat to keep the status quo a little bit, but there's still no order saying who has to pay expenses. And so the only way to get that is to file for divorce and schedule a temporary orders hearing with the court to address those interim concerns for your case.
Yeah, and I think the uncertainty, it's an excellent point, because the biggest stressor for guys either going through a divorce or modification or some sort of paternity order, whatever it may be, is not only not understanding the process, not understanding the law, but the uncertainty of what tomorrow brings. I don't know what's going to happen. And it's amplified if you have concluded that your marriage is irretrievably broken and that there's no way to preserve it, then why are you waiting? The point is that uncertainty of, well, the bills aren't going to be paid, or she stops contributing towards the mutual household expenses and still living there. And so now you're driving your debt up, because most guys I meet with are living paycheck to paycheck, and it creates stress and uncertainty. I think that's an excellent point about filing first. I'm a big advocate of moving forward when the timing is right, when you've made that conclusion. I don't want to encourage divorce unless divorce it's appropriate, right? So that's a conversation. Again, have that conversation with your attorney. Decide whether or not it's appropriate. Because I think even getting temporary orders, if you're in need of financial assistance, or maybe I just met with someone the other day where his wife is the primary breadwinner. He is stayed at home with the kids, and she has stopped contributing at all. So he has no money. So in order, to get the temporary assistance, the temporary hearing, you have to file, right, Lauren?
Right, absolutely. You're not going to get any relief from the court unless you file. So sometimes what I advise clients too is sometimes we go ahead and file and we just leave the case pending, but those county standing orders that I talked about, they at least provide some of those minimal protections, because without any court orders, there's nothing saying, like I said, who has to contribute what household expenses, what happens, like if somebody goes and spends all the money in the joint bank account and drains the savings, well, you don't really have much relief to get from that if you don't have a case on file with the court and are ready to go and have a hearing. So if sometimes I have clients that say, you know what, I want to go ahead and file just so I have some of those minimal protections in place, and then let's kind of pause, take a beat, and see if we can work on our relationship in counseling. And if we decide, after all, we want to stay married, well, then that's on the divorce attorneys to say, all right, well, we'll just dismiss your case and proceed on your merry way.
Yep. I mean, filing, I always say it's filing with a purpose. And so that means having a strategy. And do I need to file? Should I file? Is there a financial compelling reason? Those are the things. But I think the overarching, when I talk about filing first, and typically, if you've attended one of the seminars around the country I've given, it's usually, I give this as number 10. Only reason being is I want to draw attention to it to close out, but I think we did this now early because there are guys where there may be bad facts. Not every guy that comes in the door is 100% clean, and whatever it is. It could be that, yeah, okay, I argue a lot, or yeah, I spend too much money, or I drink too much, whatever it is. I've always said to clients, there hasn't been a set of circumstances or facts, absent child abuse, right, that I can't deal with, that I can't put a strategy together to put you in a position to accomplish your goal. Can't say you're going to, but we're going to put together something. And so why filing first may matter, right? Where it is, you may have bad facts, which means strategically filing first gets you to present facts first, right?
Yeah, so typically how it works is if you're the petitioner in the case, then the order of operations when you're actually in the courtroom, whoever's motion it is, gets to say their piece first. And then the second party, in my jurisdiction, we call them the respondent, they get to speak second. And so by getting to file first, that means that you're essentially framing the case for the judge. The first time the judge hears about your case is from your mouth. And so you're able to frame those issues better. And also in cases where a spouse wants to file for emergency orders or things like that, sometimes that can happen if you're not already part of the case. They can run off to court and get a restraining order without any advance notice to you, and surprise, you don't get to see your kids for 2 weeks until you can get a court hearing. Whereas if you file first, they have to, at least in my jurisdiction, provide notice to you in advance of that, saying, hey, I'm filing emergency orders, so that you have an opportunity to be heard before the judge issues an emergency order.
Yeah, judges are, I think when we talk about filing first, judges are derailed by emotion. They're human. They have an attention span. Cases may go days. I've had a case particularly went almost 2 weeks. I just can't imagine the judge being able to pay attention for every minute of every second of every cross-exam and question. And so getting an opportunity, and I've told this story and I'm not going to get into it, when I was practicing in Georgia about filing first, I was able to present a case so strong that the judge stopped listening by the time the other side got up and did any evidence. They'd already prejudged the case. And that's the point. That doesn't work every single time. But it's about having the conversation. I think if you listen to any podcast or watch any town hall that we've had, it really is premised on have a consult and have a strategy session. It's worth it because you're investing everything you've earned, everything you've worked hard for, your kids, your property, your pension, your retirement, all of it. And so I think, Lauren, that's great points about dealing with bad facts first, deciding whether or not filing first is appropriate. So great point. And I think that, of course, gets us into the next topic. And I want to talk to Adam about, and we talked about this, and I've always cautioned, I've used the word neglecting the kids. And I don't want, I've never intended that to mean from the legal term of neglecting them. And I'm curious how you feel, Adam, and I really mean this in terms of keeping the traditional parenting roles that you've had can hurt you, right?
Yeah. Unfortunately, it can, and I interpret that the same way. Nobody is accusing anybody of forgetting to feed the kids or doing anything crazy. When we're talking about neglect, it really goes to the fact that in most households there are traditional roles, and they kind of develop naturally. Let's say you're the primary breadwinner, you're working 60 plus hours a week to pay the bills. It makes sense with you and your wife as a team, as a unit, that maybe she handles more of the day-to-day parenting. It just works out that way as a matter of time. It doesn't mean you're doing anything wrong. It just means you're working as a team. Yeah. Now, when you're facing a divorce, though, you kind of have to take a step back and look at that, kind of think of it as an outsider looking in. And really the outsider we're talking about is the judge. So we're not saying you neglect your kids. We're saying that if a person from the outside looks at this family dynamic and, as unfair as this is, attaches a number or a percentage to who's doing what, then the question is, who's doing what? Is mom doing 60, 70% of the quote unquote parenting? There may be good reasons for that, but the judge is going to look at that first. And if that's where we're starting from, where mom is really the 60, 70+% parent, it's extremely difficult then to come back in a contentious litigation case to say, well, we want dad to have primary custody, or shoot, even we want dad to have 50-50. First thing the judge is going to say is, well, what have you been doing? Judges love the status quo. It is, to a detriment. They get stuck on the status quo. And it really kind of matters in two areas. When you look at custody, there's, physical custody and legal custody, which is like decision making for the kids. First, the traditional role that you and your wife have had works when you're in the same household. But you're going to have to think about it as you're not going to be in the same household. You're going to have two households. That's the nature of divorce. That's how it has to work. So you got to kind of start thinking now of, okay, if there's going to be two households, how do I want it to work? And then go ahead and start building that, working on that now, before the divorce is filed. You know, if you've been just naturally kind of ceding some roles to mom, I'm not telling you to jump in her face and cause an argument and just, just dominate everything, but you can start being a more active role. You can start doing more of the day-to-day things. And I acknowledge what I'm asking. You're still working that 60 plus hours that you're doing. You're still coming home exhausted. But I know this sounds terrible, but when you're in the divorce, you got to do more. That's the reality of what you've got to do, because you've got to look at it from the outsider's perspective. And the judge, he's not going to look at, he's going to look at it as excuses. Well, you didn't spend time because of this or that or that. But the reality is mom found the time. That's not fair. That's absolutely not fair. But that's what we've got to deal with. And I think it is a good point, because I've always said there are no winners in divorce. It's degrees of losing. And at some point, I can guarantee, the one thing I can guarantee, that everyone is going to walk away with less than what they had to start with. And that is perhaps less free time, less property, maybe less money. And so the point I think we talk about kids is, I've had that conversation, is like, look, hey, I know you maybe relied on your spouse to go to parent teachers. And I know maybe you had an agreement that she would handle the dentist. You got to start going. You got to get involved in those play groups. You got to know who your kids' teachers are. You got to know who their friends are. You got to just do it. And we've actually sent clients to individuals whose job is to work with them to become more organized and understand how to redo their life, because they really are starting over fresh. And that is a difficult thing to do. A lot of guys aren't organized. They've got to become more organized. It is a substantial change. And when we talk about, you can't wait till the case is over to do it. You got to do it during the case, the beginning of the case. If you want to have a shot at a number of things, physical custody, but not only that, but legal. And I want to talk about legal custody, because that's always a challenge to appropriately tell clients what the difference is between physical and legal. And maybe you can talk quickly about legal custody and decision-making. Yeah, I'll do that. Just with a quick disclaimer, this can vary wildly from state to state. Every state has its own rules on this. I can tell you how Georgia does it, and based on my experience just dealing with other lawyers, a lot of other states handle it this way. Physical custody is easy to understand. It's literally just where the kids spend their time, who they spend their time with, and how much. Legal custody is a bit more nuanced. It really has to do with access to information and decision-making for the kids. If, for example, you and your soon-to-be ex had joint legal custody, that means you both have access to teachers, doctors, medical records, school records, just as if you're still married. That is a must-have in a divorce, by the way. Do not get talked into any sort of sole legal custody. That cuts you out. But moving past that, so joint legal custody, there's still things you got to deal with there when it comes to decision-making. Georgia recognizes 4 big areas of decisions. Your state may vary a little, but the big 4: education, non-emergency health care, religious upbringing, and extracurricular activities. With joint legal custody, you and your spouse are supposed to, or ex-spouse at this point, are supposed to discuss those issues and come to an agreement. But even if you can't, somebody's got to have a tie-breaking power there. Somebody's got to make a decision, and those matter. Here's a good example. With education, most people are just, if a teacher says, hey, your son needs a little more help, or your son qualifies for a gifted class, most parents aren't going to argue with that. But what about school choice? Mm-hmm. What about in the realm of COVID-19? Are we doing in-person schooling, or are we doing remote schooling? Those are big issues, and parents don't agree. This can impact your physical custody too. Let's say you and your ex-wife have 50-50 custody. Well, if she's got tie breaking on education, what if she moves further away and enrolls the kids closer to her? Guess what? That impacts your time. To wrap back to our original subject area here is about neglect. Here's how that comes up to a judge. Judge, we want education decision making. No, judge, we want education decision making. Judge, we will be involved with the teachers. We will be involved. We will go to the parent-teacher association. We will do this. We will do that. The judge is going to sit back and ask, well, who's been doing it? Mm-hmm. And that is the ball drop when it comes to legal custody. This is stronger than physical custody when it comes to legal custody. Judges are adamant about the status quo. If mom has been taking care of all the doctor's visits, filling all the prescriptions, talking to specialists, you're going to have a really hard time getting the medical decision making because she's the one that's been doing it. Now, that doesn't mean, again, that you take it over right now, but you've got to think about it. There's something to be said about just sharing in some obligations, even if that means you've got to take an afternoon off work. Maybe it starts with just asking the right questions, being a point of contact. I can't tell you how important that is. When there's an issue at school, who do the teachers call? Do they call mom? Do they call dad? Do they notify both? I know traditionally you can say, well, my wife always told me about that. I didn't have to. But she's not going to be your wife. And remember, we're sitting at different sides of the table now. Yeah. So that's what you've got to do here. And that's why it matters for legal custody. I mean, I can't stress enough how important how much judges look at that status quo. Yeah. Now, that's not to tell you you cannot overcome it. You create extra work for yourself that you could avoid by just being proactive now.
Yeah, absolutely. I think it's so critical because you talk about this legal custody, you talk about what matters. Again, I've seen it far too often. Lawyers just dive right in, they file a divorce, and they don't have this conversation about what really, you should do. And positioning guys, particularly in this industry, in this area of law, that's important. So let's kind of keep moving. We have just about, I'd say 5 or 10 more minutes. We're going to get to our questions and answer session. There are quite a few rolling in. Remember, do it now. In the Q&A section, if you have a question, submit that, and we'll get to it here shortly. We have 2 more to go. We're going to roll through those very quickly. Jacob, this is a topic I've spoke on with Dr. Phil. I was the kind of the expert of the day. We talked about social media. This was at the very beginning of social media. So I'm very curious your thoughts as to whether or not you should, be actively engaged in it. Is there potential to reveal too much? Obviously, what's going on in divorce? What are your thoughts?
Hey, Scott, I think this is an excellent topic because I think that all too often I see that clients reveal too much on social media, or the opposing party serves up a nice bad fact. And so one of the first pieces of advice I give my clients when they come in during an initial meeting is that in a divorce, perception is reality. However the court perceives you, I think will control the outcome to a certain extent in how the court chooses to apply statutes, code, and case law. And so I tell my clients that a divorce, unlike other types of litigation, is as much a public relations campaign as it is a lawsuit. The image that you're putting out there has to be genuine. It has to be responsible. You need to demonstrate all sides of being a responsible, mature parent. I think that culturally, we've kind of adapted to the proliferation of social media and using it as a tool to vent, thinking that it's just an extension of contacting our friends and family, not really being cognizant of kind of the bad things that can happen by putting things out there. And so, it's always, I always caution my clients to ask, are you putting this out there for consolation and validation? And is it something that you think is benign and may have kind of, a bad repercussion? I don't think you win a case from social media, but I think you certainly could lose it.
I can tell you when you say that you can lose a case, I've had plenty of used against me, and it's rare that I use it for me. I'm not presenting evidence of my own clients' social media posts and say, oh yeah, this is why we should have custody, because typically you're not posting on social media to help defend why you're necessarily the right person to be, the primary custodial parent, right?
Mm-hmm, mm-hmm, exactly. I'd estimate that in 20 to 30% of my cases, there's a social media post, a message, some type of communication on Facebook, Instagram, or Twitter that's filed and admitted into evidence. A couple examples that I've had is there was a party served with a protective order who then the next day posted that they wanted to buy a gun. There was a party that was making kind of disparaging comments about the other. What could possibly have been perceived as benign but they were friends with the children on Facebook, and thus kind of violated, a court-imposed restraining order where the parent's not, involved in children litigation. And that one is probably, one of the more, sneaky and less sinister types of behavior. But, it's kind of, it's kind of a thing that courts take seriously because they don't want this to impact children, negatively. Also, an opposing party made a Facebook post where she bragged about lying in court, and that was filed as an exhibit against her. And so, my advice simply is, look, there's no reason that you should be posting about your divorce or your custody dispute on social media. You should set your account to private. You should be, very hyper vigilant about the image that, could conceivably be portrayed, especially in our culture now when things are kind of looked at very sensitively. And ultimately, you control the narrative. Don't do anything that would undermine your image as a responsible parent, and be cautious about events or pictures that convey recklessness, and be conscious about how the court would perceive what you put out into the social media sphere.
Yeah, I agree. And real quickly, before we move on and cover our last topic in 2 minutes, I just had a client, particularly who filed a temporary motion saying that they needed spousal support, they needed child support, they needed attorney's fees, and they were having trouble paying their bills. And what do? They post on Facebook that they're on vacation in Florida and on the beach. It's not a good image when that's the first thing that's going to be flashed before the judge of someone who acts desperate and isn't desperate. So thanks, Jacob. It's a good point. Oh, real quick, Lauren.
One of my comments that I always tell clients is anything that you post online can and will be used against you in a court of law. But I would also caution too that you want to watch out what your friends are posting online about you as well. That's something that I've been able to do a little bit of digging. It's one of my favorite parts of my job is to just snoop on people online and see, all right, well, what's their significant other posting about them? Because you might have put your Facebook profile to private, but that other person didn't.
Mm-hmm.
Oh, and now I see you hanging around people with the children that you're not supposed to be. Or, oh, hey, I see you driving around without a seatbelt on with the kids unbuckled, or something along those lines. Or significant other bragging about your new job, and now we've got child support issues. So you'd have to not only be vigilant about what you're posting, but also controlling your image for how other people are posting about you as well.
Yep, absolutely. It's a big no-no. And, we're immediately guys right now, putting their social media on private as we're speaking. So it's a good move. Last one we're going to cover very, very quickly because we have a lot of questions we want to get through. Kumudha and Adam, I want to kind of turn to you both. And I think this is important about ways to save money. We're always looking for ways to help your attorney to try to minimize attorney fees and expenses. And so one of the mistakes is that guys aren't fully participating, meaning helping their case. Kumudha, kind of talk about how guys can be a partner with their attorney.
Definitely the biggest thing in your case you have to know is you're kind of responsible for getting evidence. Obviously, your attorney can subpoena documents, but you really need to make sure you get all your documents together. Things like text messages, like I was saying earlier, communicate in writing, because that could be evidence that you really need. I mean, your word only goes so far. And I have clients who we go through what's called the discovery process, where you change evidence from the other side. And then at the last minute, they're giving me good evidence, but I might not be able to put it in trial because we didn't provide it in discovery. So really evidence is the big thing, and making sure you're engaged, following your lawyer's advice. They do tell you to keep things in writing. Do that and get a text backup app, put it all in one PDF.
Yeah. Adam, what do you think about helping, create a list of things and documents and questions and issues for your client?
Yeah, I like to joke that accountants are the best clients because they are so organized and so on top of things, I guess, because of their job. But organization goes a long way. Jumping back to the discovery, this can save you so much money. You're going to get a list of things to provide. When you show up to my office, you just drop a stack of documents at the front desk. Guess what? You're paying me probably, and my paralegal to go through that, organize it, get it in a fashion that I can understand it, and before sending it to the other side. It really helps if, even something as silly as just organizing things with Post-it notes to say, this is what this is, this is what this is, this is what this is. Summary pages are spectacular. They save so much time. I use them if I'm going to provide a lot of documents as exhibits to a judge. I always give the judge a summary page. Do that, the most, and I always tell clients all the time, the more work you can do, that's the less work I have to do, which saves you money. So absolutely be engaged and be organized. Another thing to do is, I know this sounds silly, but ask questions. Mm-hmm. It is okay not to know. It is okay not to know how to provide documents. It's okay not to know whether to organize things or something or not. It's okay not to know what the next steps are, what you need from me, what I should be, what I as a client should be doing. It's okay not to know that. But be proactive and ask. I tell my clients all the time, it's a cliche, but there is no dumb question. It doesn't exist. Ask it. I won't get mad. So that's, I think that's the two best ways that you can help your attorney is be organized and ask questions. Right. I think it's just something about lawyers. This is a helping profession. We love to answer questions. We really do. So ask away. And the more, even if it's a case that's not very combative that we hope is going to settle early, the more the more equipped you are to help me negotiate. So questions. I guarantee you we've got tons of answers for you. You just got to ask.
Yep, absolutely. All right, let's get to the Q&A section and portion of our town hall. We have a number of questions. If you haven't submitted it, do it now. We're going to race through in the 19 minutes that we have left to get to as many as we can. I'm going to stay with you, Adam. DL in California submits this question. DL's in a custody case where mom is accusing dad of having some mental health issues. The question really is this. There is a non-treating or a non-psychiatrist pediatrician that has a deposition coming up. This pediatrician submitted appears to be an affidavit based on a 20-minute meeting with dad prior to the child's birth. The question I guess DL has is kind of curious as to what questions should be asked at the deposition, what issues should be going into in the deposition, and what documents should be requested of this non-treating, perhaps, physician.
I know this sounds like kind of an obvious answer, but when it comes to documents, you want everything. This is someone who's giving expert testimony to basically talk about you as a person. You need to know everything about their background, about their credentials. You need to know everything about how they were retained, how they came to this conclusion. Any reports, any inter-office reports, inter-office communications between the other party and this doctor. Reading this scenario made me cringe a little because I can see how this would happen, but you've got to get to the bottom of that by just figuring out what in the world did this doctor actually do. I think that would be my priority at a deposition, because realistically, it's a divorce. It's not a personal injury case. You're not going to win and lose it in a deposition. I would look at this deposition as my point of finding answers. Yeah. So I want every record I can grab of his, and my questions to the deposition will be focused on what did you do to get to this conclusion. It wouldn't even be so much about beating up the expert. We'll do that at trial. What I want is the ammunition that we can use to beat up the expert. So
yeah, and DL said that he'll get some documents tomorrow, apparently, and obviously I think you're right, Adam. It's more of putting this doctor in a corner. How much time did you spend? Are you a psychiatrist? Are you an expert in that field? Are you familiar with all the psychological issues, of patients? Do you often, diagnose patients with psychological issues? Are you, just put them in a corner so that by the time you get to trial, after reviewing all the documents, now this person is pretty much worthless other than I saw someone for 20 minutes. I am a pediatrician, and that's all I can do. Right. And I think that's what DL should do. Yep. All right, let me go to Kumudha. Bill has a question. Bill's wife is on SSDI, and the question is she allowed to receive alimony when she's on SSDI?
It depends. So basically, alimony in every state obviously varies. I know there's one that doesn't have it at all. But that could be considered, what her financial circumstances are. So if you make, substantially more, she still may be entitled to alimony, because part of alimony is for her to be self-supporting. But then the other part could be that she needs to, she wouldn't be able to earn enough to maintain this lifestyle that you had during the marriage. So alimony still could be awarded even with the SSDI. But I think usually it is considered a circumstance that she would be able to support herself.
Yeah, and I think it depends on the state. I mean, if you look around, there are clear case law that talk about the definition of income is money from whatever source whatsoever, and it can be an offset to its calculation. And so certainly, and then the second part, Bill, and I'll just answer, wanted to know if buying someone out of the house is income, and it certainly isn't. It's a property asset, and it goes into the property distribution. So, Bill, I would encourage you to find, I don't know what state you're in, just do a Google, find out kind of the SSDI rules. There are plenty of case law I know that in the states that I'm licensed, all of them have guidance from the appellate courts on how to treat SSDI relative to both child support and spousal support. So it's a good transition. Derek has a similar question about maintenance, spousal support, alimony. Jacob, I'm going to go to you. So Derek wants to know if there's a calculation he can use to figure out roughly how much maintenance he's going to be obligated to pay. He hasn't filed yet. He's just trying to get ahead of it, trying to understand. And I know this is state specific. So Jacob, I'll just let you talk about your state, and then I'll talk about mine.
Yeah, that's a great question, Scott, and a pretty complicated question at that. In Utah, alimony is need-based, which makes alimony both an art and a science. Just to kind of give you a simplified version, there's 4 factors that the court will generally consider, but I really think that it boils down just to 2, and that's need and ability to pay. And there's some exceptions to that, obviously. But essentially how you compute that is the court's going to look at your expenses during the marriage. They're going to then adjust those expenses. And the science really is having somebody that can come in and evaluate her expenses and really kind of mathematically compute that and present that in a nice fashion to the court. But there is unfortunately no, unlike child support, where in Utah child support is essentially based on a matrix where it increases proportionate to income. Alimony, it isn't the same. You may have people with different incomes paying similar spousal support amounts simply because their lifestyles varied, and that variance allows a similar number. But really, the unfortunate answer is no. There's no simple way to calculate alimony. The best is to kind of review the finance, in Utah at least, review the finance opposing party and to determine the need, and then determine the ability to pay of the presumptive.
Right. And I think I'll tell you from Missouri standpoint, similarly, no maintenance calculation, no guidance. It is support-based, but I can tell you when, have a conversation with your attorney. I can tell you if you go into a particular county, what is likely to happen. There is an unwritten way that they're doing it. So for example, anywhere between 20 and 45% of available net income. I know that's a pretty good big range, but I'm at least being able to narrow it down for you. If you're in Kansas, I think Kansas is a maximum of 121 months. Texas may be the same. There are states in which there are calculations. I think Illinois just started transitioning to a calculation-based. But it is important. Do some research, gather it. There are some states very similar to child support. So let's go to Lauren. Todd has more of a general question, and I'll kind of read it lengthy. So Lauren, Todd's wife told him she was not happy last July. They've been cohabitating since then, nothing formal. They've been trying to play, or he's been trying to play financial provider for the family, role model for the kids, friend to his wife. They're getting along more as friends and co-parents. She has a boyfriend. She doesn't know why that should change their arrangement. He's still processing his feelings. She's getting the best of all worlds. He's the sole provider. And the question really is, he's being taken advantage of. This is right in the alley of filing first, right, for Todd?
Yeah, absolutely. I think that this is as long as you're emotionally ready to file for a divorce, I think this is something that needs to happen. You need to file. One of the other strategies or considerations that you want to think about in filing for divorce is if you have a problem with something, the longer that you let it go on, the less seriously the court's going to consider it as a bad fact. So if you're allowing her to, have a boyfriend and you're not doing anything about it, that kind of the legal term of art is called condonation. So is it really that big of a deal? One of my concerns would be, well, what benefits is the boyfriend getting out of this? Is she going on dates with him and, spending marital funds on her relationship with her boyfriend? What's the boyfriend's involvement with the children? Is she bringing the boyfriend around the kids? These are things that if you go to court, you can get some orders in place, absolutely, regarding that. And the longer you let this go on, the worse it is for you, essentially.
It is. She's made the decision, I think, for Todd, and that is the marriage is over. She's chosen to bring someone else in. And I think this is the example where you think, what can go wrong if I do nothing and wait for her to file? Well, she could become disabled. And now you're on the hook for perhaps long-term spousal support. A number of things. She could bring someone into the home that is abusive to children. She could bring drugs, alcohol. You could be arrested. You could be charged. I can go on and on. But the point is, in the adage, she's having her cake and eating it too.
Yeah,
There's
absolutely.
no reason for her to change anything because you're paying for everything and giving it to her.
And in Texas, the stopping point for property division is the date of divorce. And so meanwhile, you're allowing your wife to have a boyfriend and you're still continuing to accrue community property that's going to get divided. So the longer you let this go on, the more she's getting out of the financial impact of the divorce.
Yep. All right, Kumudha. Thomas works in law enforcement. Wife has demonstrated willingness to make false allegations of physical abuse in the past. He willingly moved out because he didn't want to push his luck and get in trouble with an allegation, in coordination that he's a law enforcement officer. She refuses to coordinate nights that he can spend in the guest room with one of the boys who's autistic, and really that's the only way he can spend time with him is in the home. What consideration should Thomas give when deciding if he should simply assert his rights and face false accusations, or play it safe and just be accused of abandonment?
Well, Scott, I think that, you kind of have to balance out. I think you kind of have to find a good middle ground. Obviously, you should show the court that you're taking any chance of visitation you can get until you get a court order, which may take some time. But you really want to document, as I always say, what happened, your visitations, who was there, just in case something happens and she does pull out a false accusation. You have those documents. I don't always recommend calling the police, but in some situations, you may be the one who jumps the gun, and that looks a lot better if police need to get involved. But that, I think, just building evidence and making sure that if there's another witness or something like that, that you have the evidence to show nothing's happened.
Yeah. So let me keep moving. I know we have about 10 more questions and we're running out of time. So I'm going to go to you, Adam. I'm going to move fast. So let's try to answer these in like 30 seconds, just like that. Sean did not move out. It's been 2 years. His wife has not acquired a job. A vocational expert says that she's rated well and good to get a job. She's blaming Sean that she can't find a job because of him. She has filed, but still fights to make me pay for everything. Any options to force her to move out since he has a great job and a refusal to get one, and the fact that she cannot afford the expenses and he can't afford to move out. So really becomes, a question of getting her to move out. Can he do that? And she's now seeking to do the same for him, claiming that he may physically harm her.
Well, I'll start with the bad news for being quick. I'm reading this scenario. I don't see a good mechanism to get her out. I mean, you're the breadwinner. She's not. If she went out, where would she go? And I think if you're in court anyway, you find the answer to that question. Does she have family nearby? Can she move in with her mom and dad? Does she have brother or sister? You need to be able to answer the question to the judge to where she goes. In the short term, check with your lawyer, because this varies from state to state, but protect yourself against the false allegations of abuse. Georgia, for example, is a one-party consent state to recording. I know it feels weird and awkward. You buy an audio recorder, you stick it in your pocket and you protect yourself. If you record nothing, fine. But if there's an altercation, you've got proof of what happens, and that proof will carry the day. So protect yourself and basically find an avenue of where she can move out. That is your best shots of dealing with this, I think, in a little over 30 seconds.
Yeah, right. And Sean had to follow up real quickly, and I think you answered it without even me asking the question. He wanted to know if judges are focused on facts and kind of ignore the ranting and the raving and the complaints that are really hearsay. And then, now, again, they're derailed by emotion, but I think you're right. Simply using a recorder, an example where she may say, look, I'm going to get you kicked out. I'm going to claim that you abused me. Perfect evidence, but you got to clear it with your state to make sure it's a one-party consent. So use caution, and it just needs to before you do that. So let me go on real quickly. Jacob, anonymous question: how do you address child custody when parents are considering to start the process of a divorce and want to live in separate states after the divorce? Ohio and Michigan. Ohio's original state of residency, but they've been in Michigan for only 5 months. So how do you deal with a custody case when the parents want to live in separate states?
This is a good question, Scott. I believe in most states, all but if not one, that in order for a court to make a determination regarding custody, you have to reside in that state for at least 6 months. It has to be the home state of the minor children, more accurately. So jurisdictional issues are often one of the more complicated issues, but the long and short of it is that it's incredibly important, I think, that the two parties live within proximity together at the time of an initial determination. The reason being is that if, for example, the mother were to be determined the primary caregiver, the moving outside of the state, making the determination is likely to leave you playing off the back foot, looking at less custody than you would be receiving if you lived, within a distance that joint physical custody would be practical.
Yep.
And Scott, can I jump in real quick? I know we're short on time, but I caught on that when there was a 5-month mark there. You need to talk to a lawyer right now, because the statute he's referring to, the Google UCCJEA, that's what most states follow. Most of them have a 6-month residency requirement for jurisdiction. So if you don't want this case heard where they're living now, you got to deal with it now, because when they hit that 6-month mark, it's pretty black and white. You're going to be stuck in that other state, at least litigating that case.
Yeah, fighting something you don't want to have to travel to and from. So it's a good point. I'll answer this one real quickly. Barry says, my children are over 18, so no custody issues and not a lot of contention. That being said, does it matter who files first? And Barry's in California. Well, it really depends on a number of things. And we've talked about bad facts. If there are allegations perhaps against you and property division may be an issue or attorney's fees may be an issue, of course you want to. Again, why wait? The point is that only bad things can happen. If your marriage is over, she could be hit by a bus and be completely disabled, and now you're on the hook for long-term spousal support. If she's fully capable and working, making a good wage, you don't want her to be laid off during this pandemic. You want the court to be considering things while she's fully employed. So yeah, it does matter. I think it's important, but again, it's a conversation you want to have with your attorney. It's important because I don't have all the facts. So make sure, obviously we have offices in California, give us a call, 866-DADS-LAW. Lauren, what's the difference between physical and joint custody? That's by Larry.
All right. So physical custody refers to who has actual physical possession of the child when. And legal custody has to deal with who has the actual legal decision-making rights, information rights, things like that. So in Texas, we call it a little bit different. So we call it conservatorship and possession and access, but the process is essentially the same. So conservatorship, we've got joint conservatorship and sole conservatorship. So regardless of which one, both parents have the right to talk to teachers, talk to doctors, have a general idea of what's going on. But as far as, the difference between joint and sole is when it comes down to it, who has those actual big decision-making rights for these kids? Educational decisions, invasive medical decisions, psychological, legal decisions. Do you authorize your child to enlist in the armed forces early or get married, before they're of age? Those big questions, that's the difference between joint and sole conservatorship in Texas, or that's what's referred to as legal custody in other states.
Yep. All right, Kumudha, we're hurrying up. I know we're at the 1 o'clock mark, but we're going to kind of get through as many as we can here. Robert has 2 kids. Therapist has seen both of them, concluded that mom is alienated, parental alienation syndrome, one of the children, but not the other. The question really becomes, what can Robert do with that?
So one of the things Robert can do is ask for an attorney for his children to break the therapist privilege, and basically find out what the alienation is. You know, they don't necessarily have to follow the therapist recommendation. It's the judge that makes the decision. So if there is an attorney that can waive privilege, you can get those records in. The judge can also order something called reunification therapy to help that relationship get back in order. With the younger one, it's possible the court could give them different schedules, not necessarily split custody, but more time with the younger one and then less time with the older one building up.
Yep, absolutely. Okay. Let me go, Adam. My spouse has a business. It's all cash now. She's on unemployment because of COVID-19. How is he supposed to navigate, that business valuation issue when perhaps it's an all cash business? We've talked about this in a podcast before about all cash businesses.
Yeah, that's going to be really tough. That's all cash businesses are one of the most difficult financial things to deal with. You're going to have to find other ways to prove her income. If she's stuffing the money in a mattress, that's really tough. If she's putting it in a bank account, that's the most helpful thing. You got to really track where the money's going. And judges will look at that. They understand what a cash business is. If there's deposits, they'll add up those deposits and they'll run that math just like it was a regular old paycheck. So that's the key test, is where is the money going? If the money is just going under the bed or between the mattresses, you may end up needing to retain an expert who can really dive into her business and basically give an expert opinion to the judge to say, Judge, a business of this size doing X should produce an income of Y. I hate to advise that because I know experts are expensive, but it's better than the alternative, which is just taking her word for her income.
And we talked about this on a podcast where this is kind of the age where you see all these cash businesses, makeup and, beauty goods and evening parties, and it's an all cash business, but it's sourcing that. It's finding, again, social media posts where they're advertising for, the sale, interviewing people that have purchased through them, showing that, where the receipts and subpoenaing the books and digging into the business if they filed a tax return. It's interesting. People are not that good. They can't hide money forever. So you can source it, you can trace it, and, good lawyers will find bad people. Hire a lawyer, get filed now. Last question I think that we can get to, and this is a tough one. I'm going to go Kumudha real quickly, and I'm going to ask the rest of you if your input. So we'll start with Kumudha. Miles wants to know if a foreign divorce is recognized in the United States and how do you proceed to enforce that while you're here in the United States as perhaps living here?
So what you need to do is, in the state of residency, you need to do what's called a registration process. Sometimes they'll ask for the official copy of your judgment of divorce, and then you can go ahead with proceedings in your state once that's registered.
What do you say, Adam?
I agree. I've dealt with this, I guess, with Mexican court order, Jamaican, Italian, Irish, Haitian, maybe. I think I've dealt with. I've only had an issue with enforcement once. If we had 20 minutes, I'd tell you that story because they went all the way to the Court of Appeals. Big, crazy mess. But other than that, and we ended up winning, by the way. It was enforced. So I've never run into an issue where it wasn't enforced. Do talk with your local lawyer because some states call it registration. We call it domestication. It's the same thing. And once you go, there's specific statute-based steps you got to go through, but there's ways to handle it.
Yeah. Jacob, and go real quickly for you.
Yeah, Scott. So like my colleague said, the process would be registration. It would be similar if you were registering a domestic foreign orders from another state. When the orders from out of the country, there's a different process, and the recognition in Utah would depend on compatibility with the laws here if it were procedurally the same.
Yeah.
So.
Yeah, Lauren, and then I'll chime in. I have one more question after that, and then I'll address. But Lauren.
Yes, so you're going to have to register or domesticate the foreign order here. And so typically that will involve some sort of certified copy to make sure you didn't just type up something on, Microsoft Word and are saying it's a real deal. The court may also consider, does it comport with what we consider due process? Sometimes there's issues with enforcing orders that were issued under Sharia law. I've seen that. So you're really going to have to talk with an attorney in your jurisdiction to see, all right, this order that I have, is it going to work? And also another consideration that you're going to have to deal with is if it's in a foreign language, getting it appropriately translated as well.
We've had that before. And in my Atlanta office, we did that. So RH real quickly has submitted a real late question. I can answer it very quickly because it's on point. Just really the question from RH was, when should they retain a divorce attorney? We talked about filing first. RH, I know you came in late in the seminar, but check that part out when we talked about filing first. Again, it really is a simple question. What do I have to gain and what do I have to lose? And if the loss outweighs the gain, we're filing. And that is, again, disability, especially during the pandemic, that's your biggest concern, is your spouse getting sick. And if you're the breadwinner or if they have an opportunity to become employed, it gets worse. If the marriage is irretrievably broken, there's no reason to wait. Only bad things can happen moving forward. I just don't see it. Again, timing is an issue. We want to talk about income, where you are during this pandemic. You want to be at your low point, not your high point. So encourage RH, schedule that consultation. Let's touch base again and find out when you should be filing. But again, if the marriage is broken, you got to do it. So thanks to the panel for joining us today. I know we ran long, but we wanted to get to as many as we could. Again, check us out. CordellCordell.com. Check us on social and check out our YouTube page. We're going to see town halls that date back to when the pandemic started, and we've had podcasts going on. We have a couple hundred on the YouTube channel. You can check it out by topic. You can find a thing that works for you. Give us a call, 866 Dad's Law. We're happy to meet with you via Zoom. We can do it via FaceTime. We can do it phone, or where appropriate around the country and where you're comfortable, we can do it in person. So check out next time. Tune into our webcast or our podcast coming in twice each week. And until next time, have a great week.